Right, ladies and gentlemen, good afternoon and welcome to this Statutory Wills seminar. For those of you who don't know me, my name's Alex Troop, and I'm delighted that so many of you can join us this afternoon. My only regret is that we're having to do it online in this way over Zoom. The original idea was that we were going to be doing it in person, and it would have been lovely to share a few drinks and canapes with you in chambers afterwards. Unfortunately, events have conspired against us, but this is hopefully a good way of dealing with it instead. The main event today is going to be an update that I'm going to be giving you on the law of statutory wills, hopefully giving you some hints and tips as to how to deal with some of the thorny issues that crop up in practice in these cases. This event also coincides with the launch of the publication of a book that I've written entitled A Practical Guide to the Law of Statutory Wills, which hopefully pretty much does what it says on the tin. It's been recently published. It's available from all good booksellers, as well as Amazon, I'm told. And copies are available today. There's going to be a link put on the chat and Q&A function, I think, that allows you to purchase the book. And also during my talk, I'm going to be, at the end of it, asking a question based on one of the points I'm going to be making. And if you are the first person to answer that question, I'm pleased to say you will get a free copy of my book. So what more could you ask for? Well, in fact, there is one more thing you could ask for, and that is an introduction by the former Court of Protection judge, who is Nicholas Marston. I'm delighted that he's able to join us today. And I'm going to pass now over to Nick for an introduction. So Nick, thank you very much, and over to you.
Thanks very much, Alex. Good afternoon, ladies and gentlemen. It's a great pleasure for me to be here. To have been asked to speak at this event. I regard it as an enormous honour to be Alex Troop's warm-up act, and I can tell you that apart from one mention towards the end of this, the word statutory wills will be notably absent from what I'm going to talk about. As you probably guessed, I'm on holiday in Devon. It's highly unusual to see a judge or former judge not wearing a tie, so that's the explanation for that. But through the magic of Zoom, I'm able to join you all. I've known Alex for rather a long time, and then I have to say that I've actually knew his father for even longer. Alex's father, Andrew, was a senior partner in one of the big firms of solicitors in Bristol. When I started the bar, he was a very fine criminal advocate in the magistrates' court. Somebody who I learned a great deal from in the days when junior counsel used to have to go to the magistrates and practice their advocacy skills before they were turned loose on the Crown Court and the High Court. Alex's dad then went on to become a formidably able civil practitioner. So it is pretty obvious where his son gets both his advocacy skills and his outstanding legal brain from. I was always happy to have him appear before me. And in one of his cases, he actually managed to get me into the proper law reports. Not the family law reports, but the proper law reports. And I have to say that case also made the tabloids. I will also, at the end of these short remarks, tell you something about another skill of his that not many of you will know about. Alex asked me to talk about the regionalisation process in the Court of Protection that started for me about 7 years ago, and I was sitting quietly in my room in Bristol when the door opened, and in walked Mr. Justice Baker, as he then was, who was then the presiding family judge on the Western Circuit. He said these immortal words, "I've got a little job for you, Nick, which I think you might be interested in. It won't be much extra work, but it'll give you something new to think about. Would you like to be the lead judge of the Court of Protection in the Southwest region?" Well, at this stage, having returned to Bristol from being the designated family judge in Hampshire for 7 years, and having just acquired a cop ticket and done, I think, 3 cases that I had found very interesting and enjoyable, I said yes. The moral of this story is that when a very charming High Court judge asks you to do anything, just say no. The president of the family division, Sir James Mumby, having reorganised and reformed care work, private family proceedings and financial remedies, thought he now needed to drag the Court of Protection into the 21st century. A difficult job, since the Court of Protection was at this stage firmly rooted to the 19th century. The work, which was nearly all being done in London, had grown massively because of changes in the law, changes in society, and advances in medicine, and the system was quite frankly swamped. What was needed to be done, the president decided, was to build a court structure from scratch which needed new processes, new judges trained and ready to do the work, and lawyers with the appropriate skills to do the work. The president at that stage was a man with the longest to-do list I've ever heard of, but his determination and astonishing intellect got it all done. In a cash-strapped environment, getting the resources to actually process the work in the regions was very difficult. For example, in the Southwest, we were originally offered one member of staff to do all of the Court of Protection work. After a certain amount of negotiation with Her Majesty's courts, I was able to persuade them to give me a proper team of 9 people who now operate out of the Court of Protection hub, as it is known, in Bristol, which is responsible for all of the administration of cases in the Southwest. Most cases are now also issued in Bristol. The caseload has gone up exponentially. I think in the year before I started as lead judge, there are about 20 cases in the entire region, and the turnover is now up to about 700 per year and rising. Again, when I started, there were about 3 or 4 judges with Court of Protection tickets. I should explain to you that a ticket means that you have been authorized to do the particular work and trained to do it. There are lots of different sorts of tickets, personal injury ticket, criminal tickets. There's even a serious sex ticket, which I never managed to acquire. But there are, with the Court of Protection, there are now, I think, 12 circuit judges and 30 district judges across the region. And they're in all of the court centres from Truro to Bournemouth and Portsmouth to Swindon. This means that the Court of Protection jurisdiction is now a local one for local people. It's therefore more convenient, and you have judges and practitioners who are dealing with cases on a local level, know the conditions in their area, know what resources are available, and so on. There's therefore a relationship between the local judiciary, the local practitioners, and the court users, which I hope is beneficial to them all. I want to say a couple of things about the judges who do this sort of work. First of all, it's not instead of their usual caseload, but it is as well as it. This means that local judges are even busier than previously. And of course, the majority of the work is done by district judges, who are, as you all know, absolutely run off their feet in any event. And this additional jurisdiction has been very difficult and emotionally taxing on occasions to deal with. So I'm eternally grateful to those who volunteered to step up and deal with it. The other thing which needs to be said is that most of the judges who deal with this work are formerly family practitioners whose judicial background is in public and private family law work. There are very few of them who actually did Court of Protection cases as lawyers in practice. So it's a little bit of on-the-job training going on. And I, for one, was extremely grateful to the practitioners like Alex who appeared in front of me when on occasions they had to explain things in words of one syllable to a judge who really wasn't familiar with that particular issue of law at all. Good advocacy always helps. My intention was to build a relationship of confidence between the judiciary and the lawyers, and I was very fortunate to have the help and support of the Southwest Court of Protection Practitioners Association in this. I understand this close relationship has continued. The point that needs to be made about the lawyers doing this work is that in general, they are outstandingly able and committed to it. In particular, they are committed to helping many of the most disadvantaged and needy people who use the court system, something that I quite frankly found inspirational. So, with a great deal of work the system has set up and running, what sort of work did it do? At first, the majority of the work was standard DOLS applications, personal interest work, but increasingly financial issues were being tackled. I thought I'd just tell you about a few cases to give you some examples of the work that I did, which I think is universal across the circuit. All of these cases are either reported or on easily obtainable off the legal websites. So I'm not giving away any facts or anything that's not within public knowledge. I'll call the first case the Three Brothers case. This was one of the first contested hearings that I did in the Court of Protection, and involved three brothers, two of whom were very successful businessmen, and the third was sadly somebody who'd lost capacity many years ago through a series of illnesses. And the two older brothers both were convinced that he should live with them. He tried both of them, and they were in a situation which was as near to an old-fashioned custody battle as I've ever come across in the Court of Protection. And it was resolved when I went to see P, and we talked it through. P was charming. He was obviously limited in his capacity and so on, but expressed himself very strongly that he wanted to be with one brother. When I explained to the two brothers the content of what he told me, they immediately went outside, and from being irreconcilable, they came back with their lawyers 20 minutes later, having said, well, we've listened to what's been said, and this is our program. And I'm glad to say that that gentleman now has regular contact with the, if I can put it like this, non-custodial brother, and is happily living in Cornwall with the other brother. And occasionally something like that is quite inspiring, because it shows that consultation and discussion can bring about common sense, even in the most divided of cases. I did a case from Birmingham and Bristol, which involved an Afro-Caribbean family who'd originally come from Guadeloupe. Guadeloupe is the place that some of you may be familiar with, because it's the site of the Murder in Paradise series. The family in this case had come over here, and the mother, an outstanding matriarch and a pillar of her community, had, after bringing the four children up on her own, three brothers and a sister, suffered a debilitating stroke which had left her in almost a vegetative condition. And the brothers and sister argued about who she should live with. There was a fascinating insight into Afro-Caribbean culture and the what was regarded as right by different family members. That was one that I had to give a judgment in. It was not capable of settling. Another case that I was involved in is the MH case, which some of you may have read. That was a case in which a very, very badly handicapped young lady had some marks on her that resulted in a safeguarding application by the local authority. The local authority lamentably failed to investigate the issues in the case properly. They just removed her whilst her mother was out of the country, she having been placed in respite care. The upshot of that case was tragically a 4-week High Court case, in which at the end of the case, I returned the young lady to her mother's care, and most unusually made an order that the particular local authority should pick up the whole of the costs bill. It is a case which, along with Alex's, is the only other time that I managed to appear in a number of tabloid newspapers. And it resulted in a massive cost order being made against the local authority. The last case that I'm going to talk about is one that I call the self-harming author. A young woman of about 23 who had eating disorder, which the analysis was that arose out of lack of capacity. She was incredibly intelligent, articulate woman, but she had a desire to self-harm arising out of her eating disorder, and would slash her wrists on a regular basis and so on. Over a period of 3 years, she was kept alive by medical interventions and the interventions of the Court of Protection. And I'm happy to say that in that case, the last time I saw her was to discharge all of the orders, because she had made an almost complete recovery and was having her first children's novel published 3 weeks later. So the system does work on occasions. There are also a large number of financial cases coming before the courts now, and particularly cases of financial abuse. These involve people with the power of attorney, for example, using and abusing particularly aged relatives' trusts, treating the funds of that relative as though they were theirs. The rationale behind this is usually, and quite frankly, pusillanimously in my view, put like this: well, I'm going to get it anyway, and rather me than the local authority, eh? What a self-justification for theft that is. I have seen cases in which equities of literally hundreds of thousands of pounds have been spent, valuable property, family heirlooms sold off, houses stripped of their contents, and so on, behind the backs of not only other family members, but the local authority, who then have to try and recover the assets that have gone. These are really unpleasant cases to deal with, and really give one a very jaundiced view of human beings. There are also cases which involve con men, cases where somebody worms their way into the trust of an aged person and then systematically asset strips them. In these very difficult times, I expect to see a lot more of these sorts of cases, which usually come to light when accounts have to be filed and so on. Which brings me to my only statutory will case. I said I would mention the subject during the course of these short remarks. I dealt with a son who had cut off his mother from his siblings. All the children were in their late 50s. He stopped the other three siblings having any relationship with her. And then he found, and I'm sorry to say this, he found a solicitor who was prepared to draft a will where his mother clearly lacked capacity, cutting all of the others out of her will, and it all coming to him. The case started in front of me as an application for contact to the old lady by the other three children. And gradually, over an extended period of time, the truth of what had happened came out. The horrific end of that case was that when it became obvious that the son who was doing the financial abuse had been found out, he put the lady into a car, drove her to one of his siblings' houses, pushed her out of the car, and drove off and disappeared, never to be seen again. So one encounters in these sorts of cases in the Court of Protection both the best of human beings and sometimes, I have to say, very sadly, the worst of human beings. That statutory will case brings me back, of course, to Alex this evening and the promised new insight into his character. About 5 years ago, I gave my family the present of a Greek cookery course for Christmas, as we were all going on to Greece for a holiday. We arrived at the cookery school, and on the next workstation to mine was Alex, who had been given a similar present by his wife. Needless to say, all of his cooking tasks were carried out with method, industry, and finished on time, and he actually read the instructions for each dish first, which, of course, for those of you who instruct him, is reassuring. His food looked and tasted great. So if this had been a real meeting rather than a Zoom one, we could all have tucked into a Greek meze produced by the author himself. Alex, I now have an urgent appointment with my wife and a glass of cold white wine. Let me wish you the best of luck with the book and the best of luck for tonight. Thank you all very much for listening to me. It has been, as I say, a pleasure to be Alex's warm-up act this evening. Thank you.
Nick, thank you so much. That's really, really kind and a wonderful introduction. I'm most grateful. So, ladies and gentlemen, I'm now going to share my screen. So you will hopefully be able to see my slides. There we are. And I'd like to start by referring first to the book that's been published. Here it is in all its glory, A Practical Guide to the Law of Statutory Wills. You'll be pleased to hear that I'm not today going to be taking you through the book in any way. What I'm instead going to be doing is focusing on some of the practical issues that get thrown up commonly in practice when dealing with statutory will applications, so that I can offer you some practical hints and tips on how to deal with them. And the first thing that I'd like to look at, if I may, is the threshold question, really, of does P lack testamentary capacity? The Court of Protection does not have jurisdiction to authorise a statutory will unless this threshold test is passed, unless P lacks testamentary capacity. The problem is, in practice, that there are two slightly different tests floating around, and although there is a large degree of overlap between them, the question is, in any case, which of the two tests applies? The position we appear to have reached in practice is that in any application for a statutory will, it'll be the statutory test set out in the Mental Capacity Act, which will apply to determine whether or not P has testamentary capacity. In contrast, in any contentious probate claim after P's death, it'll be the Banks and Goodfellow test, which applies to determine whether P had capacity to make the will that is now in dispute. That is certainly the conclusion which has been reached in a series of High Court decisions, culminating in the recent decision of Clitheroe and Bond, which was the decision of a High Court judge on appeal from a master at first instance. But the fact that there are two different tests does lead to some rather odd results in practice, because it opens up the possibility that P may have capacity according to one test, but not the other. So as the judge pointed out in Clitheroe and Bond, it might mean that no valid will could be executed if it were the case that a testator lacked capacity under the Banks test, but was not demonstrated to lack capacity for MCA purposes. So in other words, if P lacks capacity under the Banks and Goodfellow test, he obviously can't execute a will himself. But if he also is found to have capacity under the statutory test in the MCA, the Court of Protection would have no jurisdiction to authorise a statutory will on his behalf. So P could, in theory, fall into a sort of no man's land between the two tests, and he would have no ability to make a will himself or for the Court of Protection to authorise a will on his behalf. The converse situation could also arise in theory. In other words, where P has capacity under the Banks and Goodfellow test and so can execute a will himself, but is also found to lack capacity under the MCA, so the Court of Protection would have jurisdiction to authorise a statutory will as well. And that would lead to the rather absurd situation where a multiplicity of wills might be made in different terms. I suspect, frankly, that these possibilities are more theoretical than real, and they're unlikely to arise in practice. But the fact that they do exist provokes one to question whether it really is appropriate to have two different tests for testamentary capacity. One solution, of course, and this is the one advocated by the High Court judge in Clitheroe and Bond, is for the government to step in and come up with some new legislation. And indeed, the Law Commission, in one of its recent reports, suggested that the Mental Capacity Act should be amended to make it clear that the statutory test does apply to contentious probate claims just as much as it applies to statutory will type applications, perhaps with some amendments to make it fit more comfortably with contentious will type cases. And that was the approach suggested by the judge in Clitheroe and Bond, who said, frankly, it's not her problem, it's for the government to sort out by enacting new legislation. But an alternative solution is on the horizon because permission has been granted in Clitheroe and Bond for a second appeal to the Court of Appeal. And one of the issues on that appeal is going to be which of the two tests applies. So watch this space, ladies and gentlemen, because this unresolved question of whether we now have two tests or just one will hopefully be resolved when we get the Court of Appeal judgment in Clitheroe and Bond. There are some problem areas which commonly crop up when carrying out capacity assessments, and I'd like to touch on just two of them, if I may. The first is where P refuses point blank to undergo any capacity assessment and refuses to consent to disclosure of his or her medical records. How does one go about in that sort of situation proving that P lacks testamentary capacity such that the Court of Protection then has jurisdiction to make a statutory will on their behalf? I suggest that your first response should be think creatively. It's perfectly legitimate to seek to persuade P to undergo an assessment, for example, by explaining the purpose of the assessment in clear terms, or by giving P a choice of who will carry out the assessment, or where it is carried out, and who can be present when it is being carried out, that kind of thing. There might be an extreme case where you think that P's refusal is due to undue influence being exerted by a third party. And in that sort of situation, it could be possible to invoke the inherent jurisdiction of the High Court to make orders to reduce or extinguish that undue influence being exerted. But that's an unusual situation. Ultimately, however, the court can't compel P to undergo an assessment against his will. And so the court may just have to do the best it can on the basis of such other evidence as may be available. And that evidence could include P's own conduct. For example, if P attends court, the judge can look P in the eye and make his or her own assessment. But it could also include materials such as letters written by P, videos of P, evidence from P's family members and friends, and so on. So, for example, I was involved in a case where the question arose whether, in fact, it wasn't P, it was whether the respondent to a statutory will application had capacity to litigate. And the respondent had written all sorts of pretty appalling letters suggesting that everyone involved in the case was involved in a major conspiracy which was being run by the Chinese government, and even went as far as to saying that if someone did have to come and represent her, she would like Dominic Cummings to come and represent her, which, if anything, points to a lack of judgment. It seems to me that that did. However, despite that, the court took the view that that wasn't enough to rebut the presumption of capacity in that particular case, and so it concluded that the respondent still had litigation capacity. But the court was having to do the best it could on the basis of letters, because the respondent in that case hadn't turned up to court, and so we weren't able to assess her capacity, and she certainly wasn't going to agree to any capacity assessment being carried out on her. The fact that the judge reached the view that the respondent in that case had capacity is rather similar to the reported case which is trotted out in these kind of situations, which is Baker Tilly and McCarr, decided back in 2013. That was a case involving Baker Tilly, the well-known firm of accountants, who had to sue one of their former clients, Mrs. McCarr, for their outstanding fees. And they got an order against her. And they also got a costs order, which was subject to detailed assessment. And when they went to the detailed assessment hearing, Mrs. McCarr was acting as a litigant in person. And during the course of the hearing, she became tearful, and then she went out into the corridor and started rolling around and screaming. And the master understandably had concerns about her mental capacity. He suggested a capacity assessment, but Mrs. McCarr refused. And the master ended up making a finding that she lacked capacity based upon her behaviour in court. But that finding was overturned on appeal, and the appeal court held that Mrs. McCarr's behaviour was not sufficient to rebut the presumption of capacity under Section 1 of the Mental Capacity Act, particularly given that she had been involved in previous hearings before different judges in which she had behaved perfectly properly. So it shows that the presumption is quite difficult to overcome, and that case of Baker Tilly and McCarr is one that I've seen trotted out by counsel, in particular acting for the official solicitor on a number of occasions. The second problem area is remote capacity assessments. Before I go to that, sorry, Practice Direction 9A, paragraph 14, I should just mention that if you are making an application and P is refusing to undergo a capacity assessment, you can still apply for a statutory will, and you can simply state in your witness statement that you've been unable to obtain a capacity assessment, and Practice Direction 9A, paragraph 14 expressly authorises you to do that. And it says, quite understandably, that you should explain in your witness statement what steps you've taken to try and get a capacity assessment and why those steps have proved unsuccessful. And then you can ask the court for directions as to how you should proceed from that point onwards. Turning now to remote assessments, that's an issue obviously which has come to the fore in the recent pandemics that we've been going through. The short point here is that remote capacity assessments are perfectly legitimate. And indeed, there is a case called BP against Surrey, decided last year, where the court expressly states that they are lawful, unsurprisingly. However, That said, they do require a good deal of preparation and creativity to overcome the challenges that they present. It's difficult enough, I find, to have a Zoom conference with clients of full capacity, let alone with persons whose capacity is at least in doubt. One particular issue which tends to crop up in this scenario is whether they can be recorded, whether these Zoom assessments can be recorded. And a recording is often a very useful piece of evidence. And indeed, there's a case called Perrins and Holland, a contentious probate case, where Mr. Justice Lewison, as he then was, endorsed an Australian case where the judge had suggested that a video recording of a testator would probably be the best kind of evidence one could get for determining whether a testator had testamentary capacity. And so similarly, if you are carrying out a capacity assessment for a statutory will test, it would be extremely helpful to have a video recording of that capacity assessment so that the judge, him or herself, can see it if needs be. However, the fly in the ointment is that P may lack capacity to consent to the recording of that particular capacity assessment. So the assessor has to tread very carefully, and before turning on the recording button, needs to take a view as to whether P is able to consent to the recording, and if so, whether he or she does actually consent before the recording button is then pressed. Having looked at capacity assessments, I'd like to turn now to some of the classic scenarios in which it may be appropriate to apply for a statutory will. Obviously, the general rule is that you apply whenever it would be in P's best interest to do so, but there are certain typical scenarios where applications are made. The first one is ademption. As you'll be aware, if I make a will leaving my house Blackacre to Ben, the beneficiary, let's call him, and I then sell Blackacre during my lifetime, then the gift of Blackacre to Ben in my will fails by ademption. However, the position may be different if the house is sold on my behalf during my lifetime after I've lost capacity to manage my own affairs. That's in view of an anti-ademption provision that's contained in paragraph 8 of Schedule 2 to the Mental Capacity Act, the effect of which is that any disposal of property on behalf of an incapacitated individual will not result in ademption if the disposal is made pursuant to Section 18 of the MCA 2005. So Section 18, you'll recall, simply spells out what kind of orders the Court of Protection can make in respect of P's property and affairs. And those powers include, amongst others, a power to authorise the sale or disposal of P's property. So if the Court of Protection makes an order under Section 18 expressly authorising someone to sell P's property, and P's property is sold under that express authorisation, then the anti-ademption provision will apply and the gift in the will not fail. Similarly, if a deputy is appointed with general power to dispose of P's property and does so, then he will be acting under Section 18, and again, the anti-ademption provision will apply, and so the gift won't fail. However, there's a trap because attorneys under a lasting power of attorney are not acting under Section 18. They're simply acting in accordance with the lasting power of attorney. And so if they sell a house at a time when I lack capacity, the anti-ademption provision won't apply, and so the gift will fail. Now, in that scenario, there are two possible ways that the attorney might want to approach this problem. One would be to apply for a specific authority from the Court of Protection to sell Blackacre, the property, under Section 18. So even though the attorney might have authority to make the sale under the LPA, instead he applies for specific authority to do so under Section 18. And if that is then granted, then the anti-ademption provision would apply. But the alternative and probably better solution is to apply for a statutory will in that situation. And that was certainly the view expressed by Senior Judge Lush in a case called Re D back in 2004. He was very critical of the anti-ademption provision on the ground that it was very inflexible. You either have the gift deemed or you don't. There's no real grey areas in between that the court can explore. He suggested instead that a statutory will application should be made in that scenario, and it would be much more preferable because it would allow the court to take a holistic view of all of P's assets and do whatever the judge thought would be in P's best interests. So it may be that the judge would make a statutory will, the effect of which would be to replace the gift with something else, or to make some different provision altogether. The judge would have a pretty free hand in deciding what to do. Another scenario in which an application for a statutory will may be appropriate is where there are doubts about the validity of P's existing will. There was in the past a certain amount of doubt about whether it was appropriate for the Court of Protection to authorise a statutory will in such circumstances, because the Court of Protection was not equipped to carry out a mini contentious probate trial while P was still alive to determine whether the existing will was valid or not. Indeed, it appears that the court simply doesn't have jurisdiction to make a decision as to the validity of a previous will. However, in the case of In Re D, the judge, His Honour Judge Hodge QC, held that the Court of Protection could authorise a statutory will in such circumstances. The short point he made was that there was nothing in the MCA which said that the Court of Protection could not authorise a statutory will in such a case, and the only test was whether it would be in P's best interest to do so. In that particular case, he held that it would be in P's best interest to authorise a statutory will, rather, he said, than leaving her estate to be eroded by the costs of litigation after her death, and her memory to be tainted by the bitterness of a contested probate dispute between her children, which may extend to members of the next generation. But what about the concern that the Court of Protection is not equipped and indeed doesn't have jurisdiction to carry out a mini contentious probate trial while P was still alive? Well, the judge's simple answer was that it was simply not necessary to have such a trial. All that the applicant needed to show was that there were doubts over the validity of the previous will, and the existence of those doubts are enough to justify the statutory will application. Now, in my experience, this can be an extremely useful way to head off at the pass a contentious probate claim, which is obviously going to arise after P has passed away. The fact that you only need to show that there are doubts about the previous will, rather than proving that it is actually invalid, means that such applications are sometimes quite a lot quicker and cheaper than a full-blown contentious probate action, where the claimant actually needs to prove positively that the will was made at a time when P lacked capacity or was subject to undue influence or what have you. The downside, of course, is that the outcome is rather less certain if you are successful in a statutory will application. In a contentious probate claim, you know that if you succeed in setting aside the disputed will, then the earlier will is going to take effect, or if there is no earlier will, the rules of intestacy are going to apply. But in a statutory will application, if you are successful, then the court has a pretty wide discretion as to the terms of the statutory will, and so it's quite difficult to predict the outcome with any certainty. Your client may succeed, but might end up with a will which he's still not particularly happy with. It should also be borne in mind that there are circumstances where the court will refuse to authorise a statutory will, even where there are doubts about the validity of a previous will. And this was recognised by the judge in Re D, because he said that relevant factors to take into account in determining whether to authorise a statutory will are, and I quote, the existence and nature of the dispute and the ability of the Court of Protection to investigate the issues which underlie it. So the court may decline to authorise a statutory will if there are other claims lurking in the background. Take this example, which is one that's cropped up in my practice. An elderly farmer, let's call him Fred, makes a will leaving his valuable farm to his eldest son, let's call him John. Fred's other children are very upset, and they allege that the will is invalid on the grounds that Fred lacked capacity to make it, or alternatively it was the product of John's undue influence over Fred. So there are probably sufficient doubts in that case to mean that the court might at least consider making a statutory will. However, John, the son who stands to receive everything under the disputed will, says that even if that will is set aside, he would have a proprietary estoppel claim against the farm based on the fact that he's worked jolly hard without being paid on the farm over many years in reliance on Fred's promises to leave him the farm. John also says in the alternative that even if he doesn't have a proprietary estoppel claim, he would have a claim for financial provision out of Fred's estate under the Inheritance Provision for Family Independence Act 1975. In that scenario, the Court of Protection may be very reluctant to authorise a statutory will because it's simply not equipped to investigate the merits of the proprietary estoppel and the 975 Act claims by John. It may take the view that it's better to leave the will as it is and allow all these claims to be dealt with in the usual way after Fred's death. The third scenario I want to look at is where a statutory will may be appropriate because there's been financial abuse. And it's sad to say, as Nick pointed out in his introduction, that these financial abuse cases are increasingly common nowadays. The classic statutory will type case was Re GM and its successor case, Re Meek. These were well publicised cases about a lady called Gladys Meek. She had two relatives who were appointed as deputies, and they helped themselves to over £270,000 worth of her assets. Their conduct was described by the judge in the second case as amounting to daylight robbery. In the first case, Re GM, the deputies applied for retrospective approval of the gifts, and indeed they were partially successful because the judge approved 70,000 of the gifts, although the balance of 200,000 were not approved. That left the deputies with a liability to repay a very large amount of money back to Mrs. Meek. It was in that context that the judge, Senior Judge Lush, said that a statutory will was the missing piece of the jigsaw. What he appears to have had in mind when he said that is that if a statutory will was authorised under which the deputies were named as the residuary beneficiaries, then their liability to repay the estate the £200,000 may have become pretty academic because they probably would have inherited it anyway. But on the other hand, if the deputies were not named as beneficiaries under the statutory will, then there would be no question that they would have to repay the £200,000. So Senior Judge Lush positively advised the deputies in that case that they should apply for a statutory will. In the event they didn't do so, a new deputy was appointed, and it was the new deputy who applied for a statutory will. That came before the judge in the second case, Re Meek. And perhaps unsurprisingly, it was held in that later decision that the deputies should not be named as beneficiaries under the statutory will because they had gone about conduct amounting to daylight robbery. Mrs. Meek, the judge said, would have been horrified at what they'd done, and the last thing she'd want to do is make them the beneficiaries of her estate. So the consequence was that the security bond was called in to repay Mrs. Meek the £200,000, and the company which had provided the bond would pursue a claim to recover that sum from the two previous deputies. The upshot of this in practice is as follows. If you are instructed by people who are alleged to be guilty of financial abuse, you might first want to consider whether they are named as beneficiaries under P's will. If they are, that may give you grounds for arguing that your clients shouldn't have to repay money which they are going to inherit in any event, as unattractive as that submission may be. If they're not named as beneficiaries, then you may wish to consider applying for a statutory will. But again, tread carefully, because if your clients have been guilty of conduct tantamount to daylight robbery, then the chances of them being named as beneficiaries in the statutory will have to be pretty slim. Conversely, if you are acting for P and you think that P may have been the victim of financial abuse, you should check whether the alleged abuser is a beneficiary under P's will. And if so, you may wish to consider making a statutory will application to remove the abuser as a beneficiary. And indeed, that was exactly what happened in a case called Re M, which was a decision of Mr. Justice Mumby in 2009. The last scenario I'd like to consider where a statutory will may be appropriate is tax planning. There aren't in fact any reported cases involving statutory will applications where the driving force for the application is tax planning. And perhaps that's not particularly surprising because much of tax planning is concerned with disposing of P's assets during P's lifetime, precisely so that they're no longer part of P's estate on P's death, and so they're not then liable to be taxed when P dies. The reported cases therefore focus on applications for authority to make lifetime gifts out of P's estate for tax planning purposes. The most recent case on this issue is re JMA, where, as you might know, the court did authorise fairly substantial lifetime gifts motivated by tax planning, although that was out of a multi-million-pound estate, and the case should be read very much in the context of it being made in the size, given the size of the estate. The most important point which emerges from the decision in re JMA, which is of general application, is that there is no general rule that tax planning is in P's best interests. It is not a universal truth that P should do everything in their power to avoid tax. And indeed, there are some people who consider it their social duty to pay tax. So it follows from that if you are applying for a statutory will, or indeed the authorization of a lifetime gift, where the motivation behind the application is tax planning, then it's absolutely crucial for you to produce evidence to the court to show that it is in P's best interests in the particular circumstances of that case for tax planning to be undertaken on his or her behalf. And typically what you're looking for are previous examples of P carrying out tax planning of their own while they retain capacity, or at least making statements that suggest that they wish to do so or would be interested in doing so in due course. Anything along those lines is going to be extremely helpful. The other issue which crops up when you're dealing with lifetime gifts, of course, is affordability. And the court's not going to authorise lifetime gifts for tax planning reasons if to do so would give rise to any risk that P will run out of money during his or her lifetime. But that consideration is unique to lifetime gift applications, of course. Obviously, it has no application to statutory wills, since a statutory will only becomes effective when P dies, and by that stage, they've got no financial needs which need to be taken into account. I'd like to turn now to a rather different issue, which commonly crops up, which is the holiday house in Spain. In the modern world that we live in now, it's increasingly common for P to have property abroad. And so the question arises whether a statutory will is effective to dispose of foreign property. The answer is found in paragraphs 4.3 to 4.5 of Schedule 2 of the MCA, as interpreted by a case called In Re P, which was a decision of Mr. Justice Lewison in 2010. Those provisions are fairly complex, and I'm not going to go into them given the limited time we've got this afternoon. But the practical upshot that you need to be aware of is as follows. Firstly, a statutory will is effective. Sorry, a statutory will is not effective as regards immovable property situated abroad. So if I own a holiday house in Spain and a statutory will is authorised on my behalf, leaving the holiday house to Ben, the beneficiary, then that gift is not going to be effective. But the second rule is that a statutory will is effective as regards movable property, so for example, cash, either if P is domiciled in England and Wales, or alternatively, if the law of P's domicile states that his testamentary capacity should be determined by the law of England and Wales. So if I own a holiday house in Spain, which contains, for example, a couple of valuable paintings, those being movable property, and a statutory will is made on my behalf, leaving those paintings, to Ben, the beneficiary, then that gift will be effective if I'm domiciled in England and Wales. Alternatively, if I'm domiciled in France, then the gift will only be effective if the law of France states that my testamentary capacity should be determined by the law of England and Wales. I'd like to finish off, if I may, with a couple of procedural points. The first is the nightmare scenario of having to make an urgent application. In other words, this is where your client comes in and tells you that they want to make a statutory will application and they want to do so urgently because it relates to a P who is going to die any moment. These are the most difficult cases to deal with in practice. If you do find yourself in this situation, then the two essential things you need to do are, firstly, to make sure that you've got robust medical evidence to prove that P is about to die imminently. That really is crucial. Without that evidence, you're not going to get anywhere. And secondly, you need to do everything you can to notify both the official solicitor and the respondents to the application as soon as possible, even informally if necessary, so that they're aware of what's going on and if time permits, can make arrangements to be represented at the hearing. Even then, it has to be said that the court is going to be pretty reluctant to make an order for a statutory will in that scenario, because as Senior Judge Lush stated extrajudicially in one article, they tend to be weighted procedurally in favour of the applicant and could be in breach of Article 6 of the ECHR, the right to a fair trial. Given that reluctance, I recommend that in those kind of circumstances, you might want to consider the alternative of a holding will. A holding will is a temporary will which the court authorises simply as a holding measure until such time as the final hearing takes place. If P dies in the meantime before the final hearing does take place, then the holding will takes effect in the same way as any other statutory will. The great advantage of such holding wills are that the requirements which have to be met in order to convince a court to authorise a holding will are substantially lower than the requirements that have to be met for a standard statutory will. Those requirements are set out in section 48 of the MCA 2005, and they are as follows. Firstly, you have to show that there is reason to believe that P lacks capacity in relation to the matter. So you don't actually need to prove that P does lack capacity, simply that there's reason to believe that he or she does so. So you might get away without there even being a medical report to prove lack of capacity, if there's other evidence that at least gives reason to believe that P lacks capacity. Secondly, the matter has to be within the court's powers, but obviously making a holding will is comfortably within the MCA's powers. And thirdly, it has to be in P's best interest to make the order without delay. And so again, you're probably going to need some evidence to suggest that there is at least a risk that P may die between the date of the holding will application and the final hearing. In one case I was involved in not so long ago, the judge not only authorised a holding will under section 48, but also went a step further. She made an order that unless the respondent applied within a specified time for a final hearing, then the holding will would take effect as P's final will. That was a case where the respondent was being very difficult and did not even attend the hearing. But it was certainly a very helpful order because it meant that we avoided the costs of a final hearing altogether. And it's something you may want to consider if you're dealing with a particularly difficult respondent. The other procedural issue I'd like to deal with is costs. You'll all be aware that in property and affairs cases, including statutory will applications, the general rule is that costs will be paid by P or charged to P's estate. I have to say, it's always struck me as rather unfair. If I ever lose my marbles and my kids end up squabbling over a statutory will, then I'd very much like them to pay their own costs rather than their costs coming out of my estate. The court can depart from the general rule, and there are obviously lots of cases illustrating the situations in which it may do so, and I don't really have time to look at those cases now. But what I will do is just raise three specific cost rules that crop up in practice and I found very helpful. The first is that where parties with the same interest employ different solicitors, they will be limited to only one set of costs unless the court certifies otherwise. So take this example. P, shortly before he loses capacity, enters into a relationship with a new partner. That new partner applies for a statutory will in her favour. The respondents to that application are P's 3 adult children by his previous marriage. They are the residuary beneficiaries under his existing will in equal shares. Those 3 children don't get on, and so they each employ different solicitors. The court's reaction to that is likely to be that they are going to be limited to recovering only one set of costs. And so the other 2 sets of costs are not going to be recoverable out of P's estate. That does crop up in practice and can prove very helpful, because suddenly you will find, if you raise it, that people who are employed by employing different solicitors suddenly decide that they all want to employ the same solicitor. Secondly, litigants in person. Litigants in person in the Court of Protection are increasingly common. They can recover their out-of-pocket expenses, but there, importantly, is no rule that permits them to recover anything for their time costs. So there's no equivalence to the CPR provisions, which allow a litigant in person to recover, I think it's £19 an hour in respect of their time costs. Simply doesn't apply. A litigant in person is not going to recover their time costs, only their out-of-pocket expenses. Thirdly, if P dies during the court of an application to the Court of Protection, the general rule is that the Court of Protection's jurisdiction dies with him or her. However, the Court of Protection does retain a residual costs jurisdiction, under which, even after P's death, any party can apply any time within 6 years of P's death for an order that the costs should be paid out of P's estate. So all is not lost, certainly from a cost perspective, if P dies before you get to the final hearing. Lastly, I'd just like to touch on mediation. If you're not aware of it already, I'd like to draw your attention to the Court of Protection mediation scheme. This has been set up to assist with the mediation of COP cases and is particularly suitable for resolving statutory will disputes. Any settlement that's reached at the mediation is then put before the Court of Protection at a separate hearing for its approval, but in most cases that approval will be forthcoming. I have to declare an interest here because I'm on the panel of approved mediators, but there are lots of other mediators on the panel, including some very high-profile QCs and other leading practitioners. There are certain features of the scheme that you need to bear in mind before you decide to use it. One is that proceedings have to have been issued in the Court of Protection before any mediation under the scheme can take place. So pre-action mediations are not possible under the scheme. You could arrange them privately outside of the scheme, but they're not possible under the scheme. Secondly, as I say, there's a panel of mediators who are available, and we all charge a flat rate of £100 an hour plus expenses. And if you're instructing a high-profile QC as your mediator, then that is an extremely good and competitive rate of pay. It actually matches the legal aid rates. So you get very good people at very competitive rates as your mediators under the scheme. Thirdly, it's a requirement that the parties consider how P can participate in the mediation. Typically, participation is via the official solicitor, if the official solicitor is already involved, who often sends a representative to the hearing, or at least makes written submissions to the mediator. But sometimes someone else can represent P's wishes, or it may be that someone has gone and spoken to P and obtained a statement of P's wishes and feelings, which can be shared as part of the paperwork. Sometimes, however, it's simply not possible for P to participate, and I've been involved in a couple of hearings where, unfortunately, P's condition is such that they're simply not able to express any views or feelings at all on the matter in hand. That's okay in the sense that the mediation can go ahead, but you're probably going to need to record that carefully in the paperwork and any application to the court to explain to the judge why it is that P's wishes and feelings have not been taken into account. Fourthly, the website contains some very useful pro forma documentation, which I heartily recommend to you. It includes a settlement agreement, which I've used in other cases involving Court of Protection disputes, and I found very useful, and I recommend that you have a look at them. And finally, the scheme is being evaluated to see how useful people are finding it. The evaluation process, in fact, ends in 2 days' time, this coming Friday. And the academic who's carrying out the evaluation is going to publish a report with her results. So it's going to be interesting to see what that report says. My own experience, I have to say, is that the scheme has been running for a couple of years now. And in the early stages, the uptake was extremely slow. I'm not entirely sure why that was, but it may partly be a cultural thing in the sense that in the Court of Protection, mediation is not necessarily seen as an obvious solution in the same way as it is in other areas, including in particular contentious probate claims, where it's almost standard fare for any claim to go to a mediation at least at some point on the litigation journey. But after that slow start, things have begun to get a bit busier. People are finding out about the scheme. They're getting more interested in it. And I have to say that my experience is that both as someone who's acted as mediator, but also as someone who has acted as counsel in the case involving the scheme, it has proved successful in every case I've been involved in, that the parties have managed to reach a settlement. And in every case, that settlement has been approved by the court. And it seems to me that it is a particularly well-suited form of ADR for these kind of disputes. And so I would encourage you to give it a go. So, ladies and gentlemen, that concludes my talk. I would like to invite you to answer a question, because if you are the first person to get it right, then, as I say, you will be getting a free copy of the book. And the question that I have to ask you is, I suggested that instead of applying for a statutory will on an urgent basis, there was an alternative approach that you could take, applying for, it wasn't an interim will, there was another phrase I used for it, a something will. What's that missing word? A something will can be applied for. I'm going to stop sharing at that point. So on the Q&A, see if you can put the answer down and you'll get a free copy of the book. In the meantime, while that's happening, any questions for me? So let's just see. There's lots of correct answers to my question, I have to say, so that's excellent news. In fact, everyone's got it right, so well done, everyone. But the person who got in first with the right answer was Janet Strong. So Janet Strong, well done. You've won a copy of the book, so that'll be winging its way to you in due course. So that's my question to you. Does anyone have any questions to me? Do feel free to put it on the Q&A chat, and I'll just wait for a little bit to see if anything comes through. No, I don't think so. I've obviously answered all of your questions, which is good news. Well, listen, ladies and gentlemen, thank you very much indeed for coming along and listening to the seminar today. I hope you found it useful. Please come along to our future seminars, which hopefully will be in person, and it would be delightful to see everyone face to face once again, hopefully after a certain amount of time we'll be able to gather again. I'm told actually there is a question. Let me just have a look. Okay, the person who wants to ask a question has got a poor connection right now, so do feel free to ping me an email if you'd prefer to ask a question like that, and I'll be very happy to answer it by email. But ladies and gentlemen, thanks very much. Hope to see you at another seminar soon, and all the very best to you all. Thanks again for attending. Goodbye.